Good morning, good afternoon. Hi, everybody. Welcome to Digital Dragons Conference. We are very glad to be here with you today. And I'm Lena Marcinoska-Boulangé, and on the other side, my colleague.
Hi, my name is Monika Górska.
Hi, Monika. We are both lawyers from Wardyński and partners, and we are mainly dealing with intellectual property. And during this talk today, we will try to tell you and show you some background, how to register a video game title as a trademark. Please, during the talk, feel free to comment, to ask questions. We will do our best to answer. So let's go to the main topic. We are all aware that your game can include a lot of assets that are worth protection, but the one that is very important in our opinion is, which one, Monika?
Game titles.
Yeah, game title is, it's very good to have a good game title that will be catchy, that will attract players, around which you can build your marketing. And such a good asset, of course, deserves to be protected. And the best way to protect your game title is to register it as a trademark. So today we will try to tell you how to do it, how to select your designation, your game title, what are the most common mistakes, and why you should register your game title as a trademark.
Exactly. The question is why to do it, why to go into all that bother and register your game title as a trademark. Well, first of all, by registering your title as a trademark, you get an exclusive right. An exclusive right means that you can exclude others from using it. You are the owner of this particular trademark, and you get some strong rights connected to that position. A trademark registration allows you to protect your title for a very long time, because the initial registration is for 10 years, but a trademark registration can be prolonged, and you just pay another fee for another 10 years and then another 10 years. And just think of Coca-Cola, who's been protected for years and years as a trademark and is still a registered trademark. Secondly, when you register your title as a trademark, you obtain a very strong, very powerful weapon against any copycats, specifically against entities, against persons that want to free a ride on your success. We see many copycat titles or games even whenever there is a successful game. And it's a very easy way to take a bit of your success when someone is creating and registering or just creating and using a very similar game, or a game under a very similar title. So an exclusive right, a trademark registration, will help you to fight those copycats and to fight counterfeit games. Thirdly, when you register a trademark and you do it in a smart way, in appropriate classes for appropriate goods, you can use your trademark for a merchandise. You can apply that trademark to mugs, coffee mugs, t-shirts, toys, or I don't know, phones, if you wish. So a good registration will allow you to extend the protection and extend the trademark, the application of a trademark, to merchandise. And fourthly, maybe one of the most important aspects of registering a trademark is that a trademark is a very valuable asset of your company. It certainly increases the value of your company, and a trademark registration of a game title is something that investors are particularly interested in, and they're always looking and checking whether a prospective company that they want to buy registered game titles as trademarks. Because, as I said in the beginning, such registration gives you exclusive rights, and that's very, very important.
Yeah, and it was about why, and now let's say where.
Yes. So the first step when you consider registering your game title as the trademark is choosing the territory of protection. Please remember that there is no worldwide trademark protection. Trademark is protected for the territory that an owner chose. So if you want to sell or distribute your game in the US and US only, maybe you should consider registering your trademark for the US at the US PTO, which is the US office for trademark registration. If you distribute your game in China, then you should definitely consider registration of your trademark in China. If you distribute your game in Europe, in the European Union, then something to consider is the European Union trademark, which covers all member states of the European Union. But remember that the UK has left the European Union. Brexit happened. So if you want to sell, distribute, make available your game in the UK, you have to register your game title as a trademark at the UK Intellectual Property Office.
Exactly, and the general rule is that each country has separate office that register trademarks. Please remember that to have a trademark, you need to, of course, register it in this office. There are some simplifications because, as Monika said, if you want to have protection in all European countries, you do not need to go to each office in each country, but you can make a filing in European Union office and you will obtain a protection for whole EU. And this is some easy way to do it. And the same is with World Intellectual Property Office. You can either go to separate offices of different countries, for example, to US, to China, and so on, or you can make a filing in WIPO and just select countries in which you want to have a protection. And in general, the procedure in each country or in each office differs a bit, but in most you can do an application online. And what about time? The procedure from the filing to registration can take from a few months if you did everything correct to even a few years if there are some problems with registration. And please, the recommendation for you is always to make a filing before you start to distribute your game, because please remember that the rule is that the first file, the first obtain the protection. So you need to be first to have the protection for your title. Okay, but it's choosing the territory, it's not enough, because you also need to choose goods and services for which the game title is registered. Please remember that trademarks are always registered for goods and services. You cannot register a trademark just in abstract for all goods and services. No, theoretically, it's possible if you choose all classes, but first it increases the costs of application. And second, we'll talk about it at the end, you need to use the trademark. You will need to use the trademark in all these classes, so it could be difficult. So when we are talking about gaming, it's most likely that you will need registration in class 9, and then you will need to select video games, and most probably in class 42, for example, providing online computer programs. But as Monika said, if you want to use your game title also in merchandising, you can, for example, also make a filing in class 25 for example, clothes, t-shirts, and so on, or for example, in class 28 for toys and so on. So please remember, you need to select goods and services.
Yes, so just to underline what Lena said, a trademark functions in an association, in a link to a good, to a product, or to a service. So a trademark must be registered and must be used for a certain good. And as Lena said, if you want to merchandise your toys under the title of your game, then you choose the class appropriate for toys and other.
Sorry, one more comment. You need to decide at the beginning, because you cannot add anything to the initial scope of goods and services. If you want to cover any new item, you will need to file a new trademark.
So as you see, choosing the right class and choosing the right goods and services for which your trademark is registered is a very, very important step, because not only that it determines the protection, what you get, the exclusive right that you get, but also it entails some financial aspects. You need to file a fee or pay a fee for each class for which your trademark registration is to extend. So here we give you a sort of an overlook, brief overlook of how much does it cost if you want to register your trademark for one class. We start with the Polish Patent Office. You can register a trademark at the Polish Patent Office. That will be a national trademark, meaning that it will be protected in Poland and Poland only. Which means that your trademark will not be protected outside of Poland, and the cost of application and the cost of registration of a trademark for one class in Poland only is approximately €100. And if you want to add additional class, then you have to add another €30 to your fee. With regard to European Union Intellectual Property Office, it will cost you €850 for one class, and then second class would cost €50, and a third or additional class €150. And again, remember that the EU trademark covers all the member states of the European Union, and the UK is no longer within the EU. So Brexit happened. Please take it into consideration. With regard to international trademark, well, this is a trademark that will be protected in selected jurisdictions. You start your process, your application with some sort of a base application, could be national application. And then while motioning at the World Intellectual Property Office, WIPO, you select jurisdiction, you select countries in which you want your trademark to be protected. And here you have just a very, as I said, basic overview of how much would it cost to register a trademark in one class in the EU, US, China, Russia, and India. The cost would be approximately €2,350.
And please remember that these are official costs. So in some jurisdictions, you will probably need to, take into account some additional extra costs because of need to have a professional attorney who will help you.
Okay, so hopefully you decided on the country, you decided on the class, you know for which goods and services you want your trademark to be registered. Now you should decide what type of a trademark you want to register. And with regards to gaming, we note that word and word graphic or figurative trademarks are most popular. Word trademarks are the most popular in general because a word trademark gives a very broad scope of protection, because what is protected, what is the exclusive, the monopole, the exclusive right is the word itself. And regardless of the font, the colors, the graphics, the little pictures around the word itself is protected. So if anyone else uses the word that you registered as a trademark, then that other person risks liability. With regard to word and graphic or figurative trademarks, it is more about the visual side of the trademark, the appearance of the trademark, the graphics. The word is still a very important component of the figurative trademark, but when making a comparison, this part, this graphic, this visual side of a trademark is taken into consideration and is also assessed more in-depthly, let's say profoundly. So word and graphic trademarks, please remember that this is a registration that protects the word and how that word looks like, the visual side of that word. But of course, you can choose from other non-traditional trademarks and from some traditional trademarks such as graphic or color or 3D. And it's basically up to you what type of a trademark you will choose. You can think of, as I said, a color trademark for your game, for the title of your game, or multimedia or hologram. It only depends on your creativity, but also remember that you have to use the trademark. And usually the requirement is that you should use the trademark as it was registered. So if you register a color as a trademark, then you should apply that color to your game.
Exactly, but the trick is that not every game title can be registered as a trademark. So not every game title can be protected in such a way. To have that protection, your designation that you choose need to be fanciful, need to be ingenious. It cannot just describe the features or type of the product. So in this case of the game. So let me give you some example, the neutral example. Let's say sofa cannot be registered for furniture, or for example, chocolate cannot be registered for chocolate or even probably for sweets, because they describe the features of those products. So please avoid such designations. Also, please try to avoid some generic, not generic, but common, ordinary words that are used, especially in game industry, very often. And now we would like to do a little quiz with you, because we would like to show you some designations, and we would like to invite you to be a judges, or maybe rather patent office experts, and provide your comments whether you think that those designations could be registered as trademarks or not. And the first example in our quiz is the word designation farming simulator that was applied to be a trademark in European office. We are very curious what do you think about it, but in general, the answer for the question is that the office refused the designation. It said that farming refers to some agricultural issues. Simulator clearly shows that something simulates some processes and so on. So it's clear that the game Farming Simulator will be a game in which you are a farmer and simulate a farm. So it's clearly described the type of a game, and the office said no. I do not agree for registration.
Okay, so Farming Simulator, no. But what about Bubble Shutter? Do you think that registration succeeded and is a registered trademark? So write your answer quickly. Before I tell you that the European Intellectual Property Office denied the registration and dismissed this application. And the office stated that Bubble Shutter obviously describes the game. And the consumer, when looking at this title, when looking at this trademark, will immediately know what the game is about. The trademark names the game, really. The office said, it's obvious for any consumer that the Bubble Shutter game is about shooting round objects that are shaped like bubbles. And because, therefore, it is a descriptive term, it cannot be registered as a trademark. Remember, please, that trademark must be fanciful. They must be original. They cannot be descriptive. Therefore, the office said no, not even the graphics that are applied to this trademark help this situation. It's still, it is still a descriptive designation. It describes the game.
Exactly. And what with cyberpunk? Probably you know that this designation was filed also as a word designation, European Union trademark. And what do you think? We are also curious. Write your comment. What could I say? I can say that the office did not decide on this matter yet. At the very beginning, the Gaming Society show some allegations against this designation as a trademark, because there were voices that it's just generic for games. It describes some scientific games and showed that the game Cyberpunk it's just sci-fi game. And all those allegations were then materialized in a formal motion to invalidate the trademark. So now the matter is in progress and the office is to decide. This motion was filed January this year, so we are still awaiting the decision, and we will see whether it will be deemed to be descriptive or distinctive.
Okay, another problem. Lena told you to avoid common or ordinary designations. And that is very true. And the best example is Candy Crush Saga by King. King tried to register the word candy as a word trademark at the USPTO. And it was met with opposition from the gaming society, let's say. Gamers said that this application to register candy as a game title, as a trademark, means some sort of appropriation of a very common word, of a word that is used in gaming, that is used for game titles. And the gamers opposed it strongly because they did not agree with such a move. They even started an initiative called Candy Jam Initiative, which concerned or invited gamers and game developers to create and to publish games that would use candy in the title. And many gamers responded. And I think that King was aware of that because they withdrew their application from the USPTO, and they decided not to register candy as a word trademark. A whole different story with regards to European Union. King applied to register candy as a word trademark for the European Union. And the EU IPO agreed with this application, and the office said there is nothing wrong with this application. Candy is not a word commonly associated with gaming. Candy does not describe the type of a game, and therefore it can be registered. It's not descriptive. A consumer looking or reading a game title candy will not immediately assume that the game is about making sweets or baking cakes or things like that. I think this decision was surprising to many, specifically to those entities that opposed, because it actually goes against the arguments that were raised. The entities that opposed this registration pointed to the fact that the word candy can describe a game, specifically if the game is about, I don't know, collecting candies or things like that. But the EU IPO decided otherwise, and candy is a registered trademark.
Yeah, and the last example, two examples, sorry. Please also comment, but at the first glance, it seems that the matters are very similar to farming simulator that I described to you before. And that's true, because at the very beginning, the office refused to register them for video games and telling the same as in case of farming simulator. So in those cases, the office said no, because it's clear that the games are, in the games, the player is a truck driver who is driving a road of Europe or America. But then and this is a hope for you if your designation is a bit descriptive. But then the studio did not give up and appealed and filed a lot of evidence that the titles of the games are very popular. They filed a lot of materials, and they were, because of that, they were able to show something which we called acquired distinctiveness. So it was not a matter about immediate distinctiveness, which is from the very beginning, but acquired distinctiveness that you acquired through the use. But this case showed that the battle for registration could be really very long, and it's better to choose the designation that is distinctive immediately than to rely on acquired distinctiveness.
Yes, so first of all, choose a designation that is distinctive, but if you, for some reason, you feel attached to a designation that is not distinctive, that is descriptive, then maybe think about adding some graphics, some visuals, maybe add a subtitle, an extension or a date. And if you don't want to go into that trouble, think of using the trademark, as Lena just pointed out in this very last example, and collect the evidence and collect various materials to show that your designation becomes recognizable and that consumers recognize this trademark and they know where the game is coming from.
Yeah, but as I said, it could be risky, so be careful with that. Okay, and the next very common mistake is not checking whether there are any prior rights that are identical or similar to the designation that you choose to be a title of your game. So please remember to determine whether there are any designations that are identical but also similar, and whether they are registered or used for identical or similar goods and services. Please do not believe in false information on forums and other materials that says that it's enough to change one letter in the designation or two letters or 30 or 40% of the designation to distinguish it from other prior rights. Comparing of designation, it's not about numbers, it's about comparing, we call that overall impression. So you need to take into account various factors, correct perspective of average consumer, and then make an assessment.
Yes, and also check the market, because prior rights refer not only to the rights that are registered and that are to be checked and available in publicly available databases, but also to designations, to trademarks, let's call them, that are simply used by entities on the market. It is possible that the designation, that a game title is used but not registered. If it's used first, if it was used first before your registration, then it should be considered as a prior right. And if your game title is similar to that earlier registration, then you can be in trouble. Therefore, it is something to consider to seek assistance from a trademark attorney, from a lawyer who specializes in IP, because those persons will help you, will guide you through this process, and will tell you whether there are any risks, or whether your game title is clear and can be registered.
Yeah, and now again, a little quiz.
Yes, so look at those two designations, Iron Maiden and Iron Maiden, and just think and share your comments. Do you think there were any problems? And if there were, why do you think there were any problems? Obviously, we are online, so we can't respond immediately to your comments. I can tell you that this particular case is a good example of prior rights and the clash between prior rights and an application for trademark registration. So 3D Realms Entertainment attempted to register Iron Maiden as a trademark, and it was used as a title for their game. They filed their registration, their application at the USPTO, but they were met with a lawsuit from Iron Maiden, the music group. And Iron Maiden claimed that their trademark, Iron Maiden, was registered for goods also in class 9. They had their own video game launched 20 years prior, and Iron Maiden filed an extensive evidence that consumers were assuming that the game from 3D Realms was actually somehow linked or endorsed by Iron Maiden, the music group. All those arguments convinced 3D Realms of potential risk of confusion. That means that consumers can be misled into thinking that the game from one company, from one entity, is somehow linked or comes from another entity. This particular lawsuit was not decided in court because 3D Realms decided to settle the matter with the music group, with Iron Maiden, and withdrew their application. And they changed, yes.
And they changed it to Iron Fury, yeah.
Yes, it's very important that in the settlement, they decided to change it to Iron Fury, which apparently is not confusing and was, I think, accepted by Iron Maiden.
And what were dungeons, Monika?
Yes, what about Dungeons and Dragons? That's another example of prior rights and the risk of confusion, the problem of consumer confusion. This case actually was decided by the General Court in the European Union. Trademark Dungeons was filed by Calypso Media Group, and this application was opposed by the owner of prior trademark Dungeons and Dragons, and the owner is of course Wizards of the Coast. The European office, the EU IPO, dismissed the application because they found that there is a risk of confusion. The office said those two designations are too similar. The consumer can assume, can think that the game titled Dungeons either comes from a producer of Dungeons and Dragons or is somehow linked, endorsed. Maybe there are some, promotional links or other links. This decision by EU IPO was appealed by Calypso to the General Court. And the General Court proceeded to assess whether in fact there is a risk of confusion, of consumer confusion. And the main point and the main question that was asked and deliberated upon by the General Court was, what is the level of attention of an average consumer? Because to assess the risk of confusion, the office or the court must decide and must apply the level of attention. This is a term that describes this, let's say, knowledge of an average consumer and how the average consumer perceives two trademarks or two designations that he sees on a product or on a service. And the General Court in this particular case said that the level of attention of an average consumer of video games changed over the years. Calypso argued that the consumer is very attentive, that the consumer, when buying a game, because the games are still for a very limited group of consumers, for gamers, professional gamers, And therefore, the consumer is very well aware and recognizes the games that are available on the market. And therefore, such a consumer has so-called a high level of attention. And such consumer can easily say, oh, Dungeons is not something coming from Dungeons and Dragons. But the General Court disagreed. And the General Court said, no, that's not the case anymore. Games became mainstream, that the games are available in shops, e-shops, various online platforms, that the games are not only bought by those specialized gamers, teenagers. Games are actually sought and bought by a variety of people, a wide population, from grandmas to granddaughters and grandsons, and therefore the level of attention, the knowledge of the market should be lowered down, because your parents probably don't know each and every game that is available, and therefore they can get confused. And that was the thinking of the General Court. The average, the ordinary consumer is not a very attentive, does not know the market very well, and may, by looking at those two designations, think that the game called Dungeons has something to do with the game called Dungeons and Dragons. For that reason, the General Court said the EU IPO, the office, was right to dismiss the registration, and there cannot be such similar trademarks.
I absolutely agree with that assessment. And another tip for you is to remember to own the copyrights. Monika told you that most probably for a game title, you will choose a word designation or word and graphic figurative designation. Especially if you choose the latter, you need to think, so you have some graphic or some color, some composition included. Especially if you chose this one for your game title or your logo, you need to make a double check whether you've got copyrights to that, because it could be some artistic creation and could be a work of art. If you designed the logo on your own, probably it's not a problem, but if you outsource the logo somewhere else to a designer, to company, or when you make it in cooperation with some person, that could be a problem. That could be a problem and could be problematic. Before you file for a registration, you need to make sure that you have the right, that you have an agreement in which you've got an assessment and you are the owner, because otherwise your application, your trademark application, can be opposed, can be then invalidate, or you can be just sued because of using other person copyrights.
Yes, because you are not an owner. Remember about it. You have to be an owner of your copyright.
Yes, and then you can eat Big Mac. Of course, but the next very important rule and tip for you is when you already choose the designation, please stick to the designation and collect evidence about the use. So having the trademark registered, it's not the end of your job. And the story that is a warning is a case of Big Mac in European Union, because McDonald's lost its trademark, Big Mac, in EU. The competitor filed a formal motion to invalidate the trademark because of lack of use, and McDonald's was obliged to file evidence, and it filed some evidence, but the office said, no, it's not enough. I want to see more. So please be very careful, store the evidence, make some, I don't know, print screen, just gather materials, store them somewhere, and be prepared that they could be used in the future.
Okay, so we told you the most important aspects of how to register a trademark, your game title as a trademark. And here is a checklist of all those aspects. So once again, you have to choose the country.
You have to choose a class, so you have to choose goods and services.
Yes, you have to avoid descriptive words and common words.
Yes, so it means that you need to avoid sorry, Monika, it was repetition. I'm going for the next one. So you need to be aware of prior rights and check whether they exist, and check both whether they are registered and used.
Yes, and remember to avoid misleading the consumer. So don't choose similar trademarks, similar designations or similar trademarks to either the ones that are already registered or the ones that are used with some sort of a priority.
Yeah, then double check whether you've got copyright to your designation.
Well, and you must use it or you will lose it. And remember the case of McDonald's that Lena has just described.
And even if you've got your trademark registered, you need to be prepared that it could happen that you receive a cease and desist letter that will tell you stop use your designation, for example. So please do not panic in this situation. Do not make quick decisions that are not considered. Do not pay if there is a demand to pay. Do not publish apology if there is a demand to do so. Just consider it. Consult other people. If possible, consult a professional attorney who will help you to assess what is your situation, whether those claims are justified, or maybe they are groundless. Maybe this is just trademark trolling or something like that. So wait, give you your time.
Yes, this is really very, very important because sometimes those cease and desist letters are just sent out by trolls, as Lena mentioned, and the writer, let's say, of this letter has no rights and no claims, and they just want to scare you to some sort of payment. So you really need to take a breath, consult someone who can help you. There are organizations and foundations and law offices that offer free services or pro bono services. So check them out, see if they can help you. And also, if you get a request for payment that seemingly comes from an office, a registration office, either from the Polish Patent Office or EU IPO or any other office, and you have an information that you have to pay additional fees or you have to pay fees for prolongment of your trademark, please check the bank account number, please check the validity of such letters, because unfortunately there are many scams that well, they aim only at getting you to pay the money, and they don't come from those offices. So please be very careful. And if you're in any doubt, if you have any questions, it's better to consult someone than to pay or to respond to such a letter.
And now an invitation for you, Monika.
Yes, so we know that how to register a game title as a trademark could be only one of the aspects of gaming and of conducting a business activity in the gaming sector. We are very well aware of the fact that there are many aspects that are connected with gaming. And therefore, we invite you to read some of the articles that we prepared. Those articles aim at describing problems that you may have, or most common problems that you may have with your games, problems that you may have with your business or when employing people. So yes, please check out the website. You will find their articles not only on intellectual property, but also employment aspects, how to start your business, or what to do with AML or other data protection requirements that also apply to gaming.
And thank you very much for listening today. And we invite you to drop us a line and comment. We are open, of course. So see you soon.
See you soon. And if you have any questions, any doubts, any worries, please do not hesitate to contact us. And we are looking forward to seeing you live, hopefully.
Bye.
Bye.